Making Law Notes by MG Law. Now we will cover Banker's Lien, page number 13. Banker's Lien. So first we will see what is lien. So lien is our right of possession of property or goods for due payment. Like if there is any payment which is due, so for that due payment, any property can be possessed. The right to possess that property is called lien. Under under Indian Contract Act, it's a right instead of a contract. To have this possession, there is no need to have a contract for the possession. It is already a right. So you can take the possession without any contract. Types of lien. One is particular lien and another is general lien. Particular lien is when property possessed is connected to due payment. Like for example, if you go to a tailor for its services, and if you do not make the payment for the services of the tailor, then he will take the possession of the clothes for the due payment. That's called particular lien because the payment was connected to the property, that is the clothes. In general lien, the property possessed might not have connection to due payment. Like if the property possessed is not connected with the due payment, the payment is due for any another reason and the property was not connected to it. Okay, now what is banker's lien? Banker's lien is an implied pledge, like indirectly taken as a pledge. Pledge is like mortgage or of a movable property. Okay, the banker has the right to sell the property after reasonable notice. The banker can sell the property, but it has to give a reasonable notice. Okay, next is what where it is applicable. The conditions are the property should be in control of the bank. If the property is not in control of the bank, he cannot take the lien. The property should not be for particular purpose inconsistent with lien. The property of which the bank is taking possession should not be given to the bank for a particular purpose which was inconsistent with the lien. Okay, the property should be taken possession lawfully. As a banker, the banker should take the possession of the property legally, not by any illegal means. There should not be any agreement express or implied contrary to lien. There should not be any contract in which there is that the property cannot be taken as a lien. Okay, these were the applicable conditions. On which type of properties it's not applicable? The properties which are deposited for safe custody, the banker cannot take lien of it. The property which is in safe deposit lockers and the negotiable instruments entrusted to the banker for a special purpose, like if there is any negotiable instrument like check, promissory note or bill of exchange which has been entrusted to the banker for any special purpose, the bank cannot take possession of it for any due payment. The money deposited for a special purpose, there also it cannot take lien for any due payment. Any property left with the banker unknowingly, like if you are in a bank and if you have left something there unknowingly and if there is any due payment, the bank cannot take possession of that property. Okay, then comes trust account. There also lien cannot be taken. And the securities left with bank after repayment of loan, like if you have taken any gold loan and you have paid all the amount of your loan, but you have not taken back the property from the bank. It is left with the bank, and if you have any other transaction in which there is due payment, the bank cannot take the possession of the gold which was left with it for the other loan account. Okay, now summary of the chapter. First, we saw that what is lien. Lien was right of possession of property for what? For any due payment. Okay, then types of lien. One was particular, in which the property possessed was in connection to the due payment, and another was general lien, in which the property possessed may not have any connection with the due payment. Okay, then what's banker's lien? Banker's lien, in it we saw that it's an implied pledge. Indirectly, it's a pledge, and the banker has the right to sell the property, right to sell, but after giving reasonable notice. Where it's applicable, the property should be in control of the bank. It should not be given for any particular purpose. The possession must have been obtained lawfully by the banker, and there should not be any agreement contrary to the lien. On which type of property is not applicable? The property is deposited in safe custody, safe deposit lockers, negotiable instruments entrusted to the banker for a special purpose, or money deposited for any special purpose, or property left unknowingly, trust accounts, securities left after repayment of loan. Okay, so this was the summary. If anyone is interested in the PDF of these notes, they can get it from the description box of or the comment box. Next topic will be liability of surety, which we will see in the next video.